Oh, there's so much to talk about. Ladies and gentlemen, there's a lady who is a county clerk in Kentucky. Her name is Davis, Kim Davis, Rowan County Clerk. She was taken in custody by United States Marshals on the order of U.S. District Judge David Bunning and put in jail because she refused to comply with the court's order. And the court's order was that despite her religious objections under the First Amendment to issuing licenses, marriage licenses, for same-sex couples, she refused to do it. And so he sent her to prison in handcuffs. Now, I'm reading all the usual pablum, including from some pseudo-intellectuals and pseudo-conservatives. Can't nullify a federal court's order. You can't just blow these things off. I mean, what kind of a country would we be? Put aside the issue of same-sex marriage and focus on the bigger picture of religious liberty in a Judeo-Christian nation. Muslims, listen to me. The nation wasn't founded by Muslims or Buddhists or Hindus. No offense. A Judeo-Christian nation. And I'm not talking about creating a theocracy. They certainly didn't do that. I'm talking about the moral notions, the cultural notions, the faith notions that are behind our founding. And there's no denying it. There's no denying it. And why would we deny it? Only since June, when the Supreme Court issued its lawless opinion, taking the decision about traditional marriage / same-sex marriage out of the hands of the people, out of the hands of the states, because Justice Anthony Kennedy decided to impose his will with the 4 goose-steppers on the court. Do we have this situation? And my question is, where do we draw the line? The Supreme Court threw this woman out, basically said, too bad, do it. So we have a court upholding a court. No surprise there. But what about this? There are other clerks there, the deputy clerks who are willing to do this. She's an elected clerk. She's a Democrat. She's not willing to do this for religious reasons. Religious reasons that are protected under the First Amendment. The First Amendment exists not to protect the press from Donald Trump, you idiot, Kareem Abdul-Jabbar, to protect the press from the federal government. But it's also there to protect individuals and their religious liberty from the federal government. And that would include a district court, Judge David Bunning. Now, I want to go all the way back. A friend of mine, Daniel Horowitz, a conservative review, he said, you really need to check out page 17 of Men in Black. I'm not pushing the book. Just stick with me. I said, okay, let me check it out because, you know, I'm 6 books beyond and I haven't gone back and read the whole book lately. We have people now attacking Ted Cruz. Ted Cruz has said that what this judge did is an abomination. There's some guy named Charles Cook, a Brit, an import, at National Review Online, trashing Trump, now trashing Cruz. So what Cruz said today is reprehensible. Ted Cruz is asked to be on the show at 8:20 Eastern Time live, and we'll put him on. If anybody else running for office wants to comment on that, they can get in touch with us, and they're welcome to as well. See, these people do not understand the constitutional construct. They accept what's going on today. It's the court that is nullifying the rule of law, not this lady. It's the court that is way out of control and abusing its authority, not this lady. This lady's only in this position because of a lawless decision by the Supreme Court, decisions that should have been left to the states. Now she's being thrown in prison. And very few are rallying to her cause. No. Look, it's the rule of law. You can't. Move on. Come on. You can't keep litigating these things. Now, the rule of law. Page 17 in Men in Black. The title of this chapter is Radicals in Robes. Activist Supreme Courts have justified slavery, segregation, and racism. They helped precipitate the Civil War and set back race relations for more than a century. But instead of learning the painful lessons of the past that the Constitution must guide their approach to the law, several current Supreme Court justices are no less committed to judicial activism. Now listen to this. Recently, remember this is 10 years ago, recently Justice Anthony Kennedy, in a 2003 speech to the American Bar Association, spoke out against federal mandatory minimum sentencing laws that the courts and Kennedy are obliged to follow. Quote, I can accept neither the necessity nor the wisdom of federal mandatory minimum sentences. In too many cases, mandatory minimum sentences are unwise and unjust, unquote. Here we have a federal statute passed by Congress, signed by the President of the United States, determining federal mandatory guidelines for sentencing for federal judges. And he says that he can't accept them. I can accept neither the necessity nor the wisdom of federal mandatory minimum sentences. Kennedy again decried the federal sentencing guidelines in testimony before the House Appropriations Committee when he said, quote, I do think federal judges who depart downward are courageous, unquote. Let me repeat it. I do think federal judges who depart downward are courageous. In other words, he thinks federal judges who defy a federal statute setting forth the requirements for sentencing in certain cases are courageous in some cases, if not many cases, if they defy the rule of law. That's Justice Anthony Kennedy. It's a remarkable declaration, I wrote at the time. We have a Supreme Court justice praising justices who violate federal law, and almost no one noticed, and even fewer cared. I doubt Kennedy would be so complimentary about lower court judges or legislators defying his court rulings, and so there you have it. We have a Supreme Court in too many instances with too many justices there who defy the Constitution and the rule of law, and they do it repeatedly, and they did it in June. And the people who deserve our contempt and our outrage are the 5 justices on the Supreme Court who usurped the democratic process, who usurped federalism, and abused the power of the court to impose their personal policy preferences. And now this lady's going to prison because her personal policy preferences differ from theirs. And so when you have a Supreme Court justice who in so many cases is pivotal, talking about courageous judges who defy federal mandatory minimum sentences, as Kennedy did 12 years ago, it is he who deserves our contempt, not this lady, Davis, who's now in federal prison with crooks and criminals because she said her religion does not permit her to issue a marriage license in same-sex marriage cases. And we actually have self-identified conservatives condemning her rather than the court, condemning Ted Cruz, who put out a blistering statement today, Rand Paul, who put out a statement today as well. And I guess next they'll condemn me. These are people who do not understand the Constitution and don't care to understand the Constitution. They've surrendered it along with the left. Would they have followed the Dred Scott decision? Would they have followed the Plessy versus Ferguson decision? The Korematsu decision? Is every decision by the Supreme Court to be complied with no matter what? Well, Mark, individuals cannot decide. Individuals always decide. We have a national holiday named after Martin Luther King. He defied the law, too. We've got activists, leftists, dressed up as judges all over this country now, thanks to Barack Obama and the federal system. We have them on the Supreme Court. We have Kennedy, who threw over with the other side a long time ago. And when you read Kennedy's decisions, as I have, on the issue of sex, whether it's the Houston case, the sodomy case, and other cases, the DOMA case and so forth, he has taken it upon himself to slowly but surely change the definition of marriage and impose his will on the entire nation. It didn't matter what the people of California had to say. It didn't matter what the people of any state had to say when they amended their constitutions. It didn't matter what their elected representatives or governors had to say. Justice Kennedy decided what love means. It wasn't based on the Constitution, certainly not ours. And in a diabolical way, that's what he did. Piling one phony opinion on top of another phony opinion. And so you have people in this country of deep faith. Does that mean they're not allowed to hold public office? They have to make way for everybody else? Move along, this is inevitable. And then we have the joke. When a court is violating the rule of law, defying the Constitution, then we have so-called conservatives saying, accept it, accept it, accept it. Accept the supremacy of the judiciary. But that's not what the Constitution created. There is no supremacy of the judiciary. Marbury versus Madison. That's not in the Constitution. That's John Marshall, the Chief Justice, who wrote it. And by the way, I condemn it in Men in Black in some significant respects. We cannot be a country by the judiciary. And this is a perfect example why. Will we defy a court that rules that black people are still property in the territories, like the Dred Scott decision? Lincoln defied it. Separate but equal is equal. The Plessy decision, another Supreme Court case? No. We would object. We'd say no. This is the problem. When 9 people, 9 lawyers dressed in robes, stare down at the country and impose their will. This is the problem when I get callers that say, can't we bring a class action suit? Bring it to whom? For what? It's the federal government that's the problem. No respect for the 10th Amendment. None whatsoever. No respect for federalism. The federal government has specific powers granted under the Constitution. The states have the rest of the governing powers, and the individuals have unalienable rights. And you're going to see an increasing amount of this intolerance by the left, intolerance by the judiciary, thanks to those 5 justices imposing their will on public officials, elected officials, small business people, you name it, who are going to be forced to do something that they personally reject. It's not that they're haters. It's not that they want to stop anything. It's that they do not wish to participate. And all of a sudden, that which was lawful 3 months ago is unlawful today. All of a sudden, the Constitution, the words sprang out of the 14th Amendment. Like all the other left-wing agenda items, sprung out, out of the 14th Amendment. And there they are. Can't you see it, everybody? Well, Justice Kennedy sees it, and that's all that matters, right? Wrong. Wrong. Marriage is a state matter unless it truly violates the 14th Amendment, as in race cases. These are not race cases. These are not race cases. Again, please don't call me you're for same-sex marriage, you're against it. That's not the point. It's not the point. The rule of law is the point. And here we have a lady defying a court order and said that she's violating the rule of law. No, she's not. She's asserting her First Amendment rights against the federal government, a judge. And she's challenging what the Supreme Court did, which was so abusive and outrageous. And Justice Kennedy should be ashamed of himself for the way he set this up over the years. The Lawrence decision, the DOMA decision, and then the final decision. And I wrote all about it in Men in Black, exactly where he was going with this. So he has succeeded in abusing his office, imposing his personal policy preferences on the entirety of the nation, and now this lady is in federal prison as a result of him. And there will be more who go to prison. And what are we supposed to say to all of them? Follow the court order? Follow the law? Well, ladies and gentlemen, when the law is used to violate the Constitution, is that the law? I read to you what Justice Kennedy said in 2003 to his fellow judges and justices. Defy a federal statute that sets sentencing requirements. He said defy it. This doesn't really go to the lady in Kentucky. This goes to your Supreme Court. Because everybody thinks, oh, the court's never wrong. Oh, you got to follow the court. We even hear pretend conservatives do the same thing. Oh, the court, the court, the court. Somehow people get on black robes. There's 9 of them, and the 5 of them make a decision, and they decide what's fundamentally right and fundamentally not there and fundamentally wrong. Move along, move along. You hear them all. We have lost our ability as Americans to think for ourselves, to act for ourselves. No, I'm not promoting anarchy. I'm promoting the Constitution. What the hell is the Supreme Court doing involved in these marriage cases? Let me tell you about the Dred Scott decision. You hear me talk about it, but you probably don't know a lot about it. And this is all in Men in Black. Dred Scott was decided in 1856. It's one of the most infamous cases in American history. Scott was a slave whose master, an army surgeon, had taken him to posts in Missouri and Illinois and what is now Minnesota. When Scott's master died, Scott was inherited by his widow. But encouraged by white friends, Scott sued for his freedom on the grounds that he had lived so long in free territory. The questions before the court were whether Scott was a citizen of the United States with a right to sue in federal court, whether prolonged residence in a free state had made him free, whether Fort Snelling, part of the Louisiana Purchase, now Minnesota, was free territory, and whether Congress could enact a law that banned slavery in the land acquired in the Louisiana Purchase. Chief Justice Roger Taney wrote the majority opinion. And the court ruled that because Scott was not a citizen of the United States, he didn't even have standing to sue. Taney argued, that's the Chief Justice, that when the Constitution was ratified, citizenship, quote, was perfectly understood to be confined to the white race, and that they alone constituted the sovereignty in the government, unquote. That is a lie, by the way. But Taney was a racist from South Carolina. So blacks were not citizens. The opposite, however, was true, as I write, as Abraham Lincoln pointed out in a speech in June 26, 1857. Wow, Abraham Lincoln defying the Chief Justice of the Supreme Court. Abraham Lincoln defying the Supreme Court altogether. Lincoln cited the dissenting opinion of the Supreme Court Justice Benjamin Curtis. And by the way, so much for these people who say Lincoln was not really concerned about slavery. He was very concerned about it. Read the Lincoln-Douglas debates, among other things. So Lincoln cited the dissenting Supreme Court Justice, Benjamin Curtis, who showed, quote, that in 5 of the then 13 states, to wit, New Hampshire, Massachusetts, New York, New Jersey, North Carolina, free Negroes were voters, and in proportion to their numbers, had the same part in making the Constitution that the white people had, unquote. In other words, The facts, so-called, Taney used to support his conclusion were simply wrong. As for Scott's residence in free territory making him free, Taney rejected the argument, but with little explanation. He devoted only 1 page of his 55-page opinion to the subject. And on the final point, Taney concluded that the Fifth Amendment prohibited people from being deprived of life, liberty, and property without due process. And because slaves were property, any congressional ban on slavery in the territories of the Louisiana Purchase was unconstitutional because it would be a denial of property without due process. The Supreme Court. Now, we ban the Confederate flag. Should we ban the Supreme Court? Should we ban the Democrat Party? Follow the law, they say today. Follow the law. Follow the law. But Taney's ruling ignored Article 4 of the Constitution, which, as the great Michael McDonald, who I have enormous respect for, a former federal judge, pointed out, Article 4 vests in Congress the power to adopt all needful rules and regulations for the governance of the territories. And nothing in the language or history suggests that decisions about slavery are an exception, he wrote. Under traditional canons of constitutional interpretation, the court should have given effect to the Missouri Compromise and declared Dred Scott a free man. Taney presumed, in McConnell's words, that a statute can be unconstitutional because it violates unenumerated rights. In this case, an unenumerated right to slavery, or maybe an unenumerated right to same-sex marriage. McConnell quotes Justice Curtis's dissenting opinion in Dred Scott, which says, quote, when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we no longer have a Constitution. We are under the government of individual men who for the time being have power to declare what the Constitution is according to their own views of what it ought to mean, but not what it says. This is exactly the problem we face today. 1896, and by the way, that case led to the Civil War. 1896, Plessy versus Ferguson. You've heard me mention this case. The Supreme Court examined the constitutionality of a Louisiana law requiring railroad companies carrying passengers in their coaches to provide equal but separate accommodations for the white and colored races. This is where we get separate from equal from. The law was challenged under the 14th Amendment, which, by the way, actually applies. And that prohibits states from, quote, making or enforcing any law which shall abridge the privileges and immunities of citizens of the United States, I'm quoting from the Constitution, or shall deprive any person of life, liberty, or property without due process of law, or deny to any person within their jurisdiction the equal protection of the laws. This was specifically written to once and for all treat black people like human beings. And yet an activist court did the opposite. The Supreme Court. The majority on the court, led by Justice Henry B. Brown, upheld the constitutionality of the Louisiana statute. Brown wrote, quote, we cannot say that a law which authorizes or even requires the separation of the two races in public convenience is unreasonable or more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children in the District of Columbia. So in Plessy, an activist Supreme Court upheld a state law that mandated segregation and forced a private industry, in this case the railroads, to separate individuals on account of their race. And yet the 14th Amendment was specifically adopted to prevent this sort of thing. Adopted, by the way, by the states. By failing to invoke the plain language of the 14th Amendment, the court inserted its own segregationist version of what was just. So like Dred Scott, the court's decision would have terrible consequences. The doctrine of so-called separate but equal was the law of the land for nearly 58 years, until the court finally reversed course in the 1954 Brown versus Board of Education decision. Want to hear more? about the great Supreme Court. Oh, the Supreme Court's had great decisions. It's had, routine decisions. But I'm telling you about this because you even have conservatives who pretend that they're smarter than you going on and on, oh, you got to follow the rule of law, Really? Well, who is it that's following the rule of law and who is not following the rule of law? The Korematsu decision, 1944. The Supreme Court upheld military orders issued by then-President Franklin Roosevelt, establishing military authority for the forced internment of Americans during World War II. This is 70 years ago. The court's opinion, only about 20 pages long, was devoid of any legitimate constitutional basis for upholding FDR's orders. More than 110,000 law-abiding individuals, mostly Japanese Americans and Americans of Japanese ancestry, were removed from their homes on the West Coast, relocated to camps in the interior of the country, and detained without cause. The Fifth Amendment, I'm telling you, this is centralized tyranny. The Fifth Amendment states that, quote, no person shall be deprived of life, liberty, or property without due process of law, unquote. If this wasn't a violation of the Fifth Amendment, then what is? So rather than applying the clear language of the Constitution, this activist FDR court simply upheld his policy. Indeed, the court dismissively concluded that war demands sacrifices and that certain groups will have to bear certain burdens. Given the sheer inhumanity of these decisions, it's difficult to understand why so many regard the Supreme Court as the most moral and just of the three branches of government. These cases are crucial to understanding the danger inherent in judicial activism. When the judiciary utilizes outcome determinative reasoning rather than adhering to the Constitution, the result can be catastrophic. Which brings me back to Anthony Kennedy. And that speech in 2003 to the American Bar Association, where he rejects federal mandatory minimum sentencing laws passed by Congress and signed by presidents, and he's obliged to uphold. I can't accept neither the necessity nor the wisdom of federal mandatory minimum sentences. In too many cases, mandatory minimum sentences are unwise and unjust. So he decrees. And so he tells the House Appropriations Committee, I do think federal judges who depart downward are courageous. That is, I do think federal judges who defy federal law and impose their own sentences downward, that is, more lenient sentences, are courageous. Are courageous. A remarkable declaration from this justice of the Supreme Court. So before we go on and on about this brilliant judge, this district court judge in Kentucky, and upholding the rule of law, the rule of law is handed down by 5 justices on the Supreme Court imposing on the whole nation their personal policy preferences. Maybe we should at least think twice. Because this clerk in Kentucky, she has her faith. And her faith, ladies and gentlemen, does not conflict with the Constitution of the United States. It conflicts with Anthony Kennedy's personal policy preferences. These justices on the court, those 5 in particular, led by Anthony Kennedy, they're happy with what they did. They're thrilled that they turned the 14th Amendment inside out to advance a policy position, a personal position. They look around the country now and they're very excited because the lower federal courts are going to enforce their will. Attorneys general throughout blue states and other states will enforce their will just by issuing an opinion and getting a mere majority of 5. Suddenly, with one justice, Justice Kennedy, we now have a new definition of marriage. No amendment to the Constitution. In fact, contrary to any amendment to the Constitution, which could never get ratified. This position was imposed on the American people. Whether you agree with the ultimate position or not is not even my point, of course. So much for separation of powers. So much for federalism. This is why I say we live in a post-constitutional republic. We have people at National Review, founded by William F. Buckley, Jr., trashing today Ted Cruz, who has pointed out what an abomination it is to put this clerk in a federal prison as a result of her position, that there are other ways around this. Obviously there are. But a federal judge has said, you do what I tell you to do. You do what Anthony Kennedy told us to do. You follow his personal policy preferences, and you do it, or you're going to prison. I'm taking your liberty away from you. And we have conservatives cheering the judge. Ignoramuses. We have a great senator on the phone with us who wanted to speak to this issue of this clerk being thrown in federal prison or federal jail at the direction of a federal judge. Senator Ted Cruz, how are you, sir?
Mark, it's very good to be with you. Thank you for having me on.
This is an absolute unbelievable outrage, is it not?
It is exactly that. Today we've seen judicial lawlessness cross over into judicial tyranny. For the first time ever, the government has arrested a Christian woman for living according to her faith. And this is wrong. This is not America.
And what's amazing about this, Senator Cruz, is what's really happening here, and I talked earlier in the show about Dred Scott and Plessy and Korematsu and case after case.
Yep.
People hold the Supreme Court up like it's morally superior to the rest of the branches of government. It's morally superior to the people in the country. Justice Kennedy has, in a deplorable way, gradually, couple of cases, moved to this result. It is result-oriented. It's his personal policy preference. So he constitutionalizes his personal policy preference. And now this woman, who is a Christian, who is an elected clerk, who's a Democrat, says, I can't do what Justice Kennedy and these other justices are directing me to do.
You are exactly right, and I would point out that Chief Justice Roberts, in dissent, rightly observed that the marriage opinion has nothing to do with the Constitution. And Justice Scalia's dissent, which is powerful, I'd urge every listener to read it, he observed that the court's opinion was so contrary to law that state and local officials would choose to defy it because it was lawlessness. It was 5 unelected lawyers declaring themselves the rulers of 320 million Americans, and it was fundamentally wrong. I stand with Kim Davis, unequivocally. I stand with every American that the Obama administration is trying to force to choose between honoring his or her faith or complying with a lawless opinion.
It's amazing to me, though, how quickly Republicans and even pseudo-conservatives fall into line, isn't it? They just fall into line. The court has spoken. Move along. What do you mean move along?
Well, Mark, you're exactly right, and I'll tell you about half of the Republican candidates for president in 2016, when this marriage decision, this illegitimate decision came down, immediately announced the issue's decided, accept it, it's the law of the land, surrender and move on. That's word for word Barack Obama's talking points, and it's fundamentally wrong. And, I've got to say also, there are a lot of politicians today, both Democrats and Republicans, quite a few 2016 candidates, who are tut-tutting publicly that Davis must resign. If you have an official that doesn't follow the law, she must resign. Let me say to every one of them, they are defending a hypocritical standard. Where is the call for the mayor of San Francisco to resign for creating a sanctuary city, resulting in the murder of American citizens by criminal illegal aliens welcomed by his lawlessness? Where is the call for President Obama to resign after 6.5 years of ignoring and defying our immigration laws, our welfare reform laws, and even his own Obamacare? When the mayor of San Francisco resigns, when President Obama resigns, then we can talk about Kim Davis. But for every talking head who goes on television and says this one county clerk in Kentucky is a threat to our liberty, what they are saying makes no sense.
You know, Senator Cruz, you and I, we understand as best as we can the Constitution, and there's a difference sometimes between what the Constitution says and what a court says the Constitution says.
Absolutely.
And we have in this case 5 justices, 4 leftist Democrats, and Justice Kennedy, who's been on this agenda now for well over a decade. We have them perverting the 14th Amendment, defying the history of the 14th Amendment. Their opinion is absurd. And now anybody in an elected position or a position of authority who got there before this decision is now going to have to uphold this decision, even if it defies their faith?
You are absolutely right. And, you know, the position of everyone who is blasting Kim Davis, and you're seeing it from both Democrats and Republicans right now.
Yes.
The consequence of their position boils down to the belief that Christians should not serve in public office. That's the consequence of their decisions. Or if Christians do serve in public office, they must be willing to disregard their religious faith or be sent to jail. It is difficult to think of a proposition more contrary to who we are as an American people. As you know, there is a reason that the very first liberty protected in the very first clause of the First Amendment is religious liberty. It is foundational for everything else. The freedom of every one of us, of every faith, to worship God, to live according to our faith, and not have government get in the way. And we have gotten so far from the values this country was founded on, we now have the government locking up Christians and throwing them in jail. And by the way, if I'd have said 6 months ago on your show that the government was going to be locking up Christians for refusing to embrace and implement themselves gay marriage, you and I would have both been dismissed as conspiracy theorists who were making things up because it would never happen. And if you don't believe the religious liberty threat is real, they are coming for each of us, and Kim Davis is only the first. Your pastor, your rabbi, your pregnancy crisis center, the Christian university that follows the biblical teaching of marriage, all of those are next in the line, persecuting religious liberty. And I believe every believer, every constitutionalist, every lover of liberty should stand with Kim Davis, and we should stop this persecution now.
Yeah, I predict now they're going to unleash the IRS to take the tax status away from religious institutions, churches, synagogues, what have you. And look what happened in Oregon. They broke the back of that small business. Yep. I mean, this is spreading. It's spreading quickly. It amazes me that the left is able to portray this as compassion, as tolerance, when it is the opposite. And I resent what Justice Kennedy and these 4 justices did. They amended the Constitution of the United States without going through the process, and now we're going to have case after case. And this federal judge, Ted, didn't have to do this. He asked those deputy clerks if they would issue those licenses. 6 out of 7 said yes, but he wanted to bring down the iron fist on top of this lady.
It is arrogant judicial activism. It is hubris. It is the desire to punish Christians, to punish anyone who stands for their faith.